Welcome to our policy committee meeting. Thank you all for coming out this afternoon. My job is done. Angel? Or Mr. Odom?
Hodge says there are some folks that would like to speak on number 14.
Okay.
We go let them go first.
Sure.
Coach White here?
Yes.
Okay. I'll just bring us up to date on this. Probably 3 or 4 months ago, I was approached about drug testing within the school as far as athletic programs and stuff like that. And spoke to Coach White, football coach at Siegel, and basically told him he would have to come to the board and give the board give the policy committee his ideas and stuff like that. So that's why he's here now. So.
Coach, welcome.
Thank you, guys. I appreciate you listening to me this afternoon. Actually, I've got some things that I've kind of researched and done, thrown some things together. This is just kind of a rough draft. If you guys kind of want to look through those as I go through, if you want to take those and just pass them down there.
May not be enough. We'll share.
I noticed that Mr. Odom and his staff designed a new mission statement that's on the website that I noticed, empowering today's students to grasp tomorrow's opportunities. I think that's one of the things that I see that we can do with the drug testing program. And when you say drug testing, everybody immediately goes into the legal panic mode, I understand. With the proposal that, or what I've handed you guys, I think we've gone through and I've spent some time and not just in the testing aspect, but the education aspect and also the counseling aspect of what we can do. Give you a little history about me. I'm from here. I've been in this county 20 years, coaching and teaching here. I've been here since 1990. I've seen a lot of players, not just good players, but just players get eat up by the streets as well as many youth guys that have been around for quite a while, Mr. Tackett. I know you have too. I've also seen an increase in drug and alcohol use in the last 5 years in our athletes, and I know it's school-wide. And I know this because kids today are not, they're not ashamed to talk about it. And there's not that stigma that goes along with it in the schools as much as it used to be. And I feel like that's one of the reasons that we need to think about this. Kids don't hide it much anymore. If you go through and you look at stats, and I've spent the whole weekend looking at stats and looking at the increase in marijuana use amongst 12th graders in one study that I looked at, 40% of 12th graders have tried marijuana or been involved with marijuana within the last year. That's 40% of 12th graders. It drops down to about 32% for 10th graders, and it drops down to about 30% for 8th graders. But there's been an increase over the last 8 to 10 years in just this one drug, and everybody knows that it's probably a gateway drug into other things. I don't know if some of you guys know my story. I've been affected within the last year. I've got a son who graduated from Riverdale High School, one of the smartest kids that I've ever known. Got the presidential scholarship over at MTSU. Moved out of the house, graduated a year early from high school. Moved out of the house, which was our mistake, and he ended up being hooked on synthetic drugs. My wife has championed a cause that she's out speaking about with other folks around the mid-state area. It's everywhere. It happened in my house, okay? And I'm aware of what things go on. It can happen to anybody and any time. And I want to give our kids an opportunity here. A couple things that I've learned in the process of doing this. One of them being that I surveyed a few coaches in the spring when I knew that I was going to do this. Out of the 9 coaches that I got, out of the 10 coaches that I got surveys back from my high school at Siegel High School, 8 of them are for this, okay? The other 2 are for it with stipulations, and the stipulations being that it's not just athletes that are tested. I don't make that decision. All I know is I want to take care of my 150 kids I got in my program. Some other things that I've learned. I polled the football coaches in the county from the 6 biggest high schools, and 5 out of the 6 of them are for this, with the 6th one being, again, with stipulations that it be for, not just student athletes, but it be for other, any extracurricular activity. And that was his stipulation. So the consensus to me among coaches, and I haven't done, it's not scientific, and I haven't talked to every coach in the county, but there's a pretty good consensus, or an overwhelming consensus, that coaches would like this in our county. I've also learned this, and this is probably the most valuable lesson that I've learned. There's a ton of questions to be answered about this. And it's not, who wants it and who's against it. There are a lot of questions. Probably the biggest thing is the cost. And that's the number one thing I know you guys are going to ask is, what's the cost? I've talked to a few people. I've talked to Aegis Laboratory up in Nashville. I've tried to get in touch with Drug Free. I've talked to the head athletic trainer at Gallatin High School, in which they do drug testing in their schools up there. I've got anywhere from $11 up to $25 up to $40, depending on what you want to test for per test. How that figures out, I don't know. Who do we test? That's probably another big question. Well, if you're gonna test athletes, why are you not going to test band and choir and everybody else? I don't know. I can't make that decision. Like I said, I'm up here fighting for my 150, 160 kids I have in my program. And that's something that has to be answered. I understand that. I will tell you this. We've got to make a stand for our youth. And it's getting harder and harder every day. You guys know it. You're in the business of education. I tell my kids on the football team, when they go into a party, if somebody dumped a box of rattlesnakes in the middle of that party, I ask them what would they do. Most of them say they'd run. But then I say, well, but if you go into a party and somebody's drinking or somebody's lit a joint up, what do you do? And most of them will look at you and go, well, I usually stay around. Well, there are more people killed by drugs and alcohol at their age than there are rattlesnakes any time, but they're scared to death of them rattlesnakes. We've got to make them scared to death of going into these parties and being around this alcohol and these drugs, in my opinion. I want to give them a reason to go into this party and say, I cannot partake. I can't partake because I know that there's a possibility I might get tested. And my sport or my curricular activity means more to me than indulging in what I'm a part of right now. We need to provide them with more education. I don't know that our kids get enough. I think they get it when they're little. I don't think they get enough of it at the high school level. And I'm a PE teacher, okay? And I'm saying that, and I truly believe that. I don't know that we're getting enough beating them into them over and over again. I don't know if we're getting anything that just relates with high school kids, okay? And we need to provide an easy, accessible counseling for students and their parents when this problem arises. I don't know that we need to provide it, but we need to be able to guide them that way, something that's easy. The one thing I found when my son, when I found out that he was messed up with synthetics, was that it's an arduous process to try to get a kid into rehabilitation. He spent 30 days at a rehabilitation center up in Nashville. It's not easy. Y'all know our insurance doesn't cover that. He got 4 days. Our insurance, we called him up and they gave him 4 days at this place. And it was $25,000 to put him there. And they paid for 4 days of it. He needed all 30 days. He was sent to a mental institution because he overdosed. And he got his rights taken away. So we had no choice, and we gave him no choice. That's when we finally stood up and said, we can't let this go on anymore, okay? We need to find some way to make it easy and accessible to not just the kids, but the parents, to be able to guide them somehow or another. It's not gonna be easy, but nothing worth, and you guys know as well as I do, nothing worth doing is worth doing it right. If you're gonna do it right, you might as well do it all the way. But it ain't gonna be easy. When you guys started the whole mess last year, and I don't mean it in a bad way, when the whole deal with the Booster Club started going down last year, it was hard. And y'all know it was very hard. It's hard on me because we all had to change the way that we were thinking, that we had thought for the whole 20 years I've been coaching, and the things that we thought that we were able to do, we had to go back and change them. This year's a piece of cake. And next year, it's all going to be secondhand. Everybody's in line. Well, it's the same thing when you start something like this. The first year is going to be tough because people are going to raise Cain. I understand that. But I think if we stick next to our guns, then I think it's going to pay off in the long run. Whether it be 1, 50, 100 through the years, whatever it is, it's worth it to every one of those kids that gets help, in my opinion. You're going to get questions. What about invasion of privacy? Well, I put the law stated by the Supreme Court on the front of that. The Supreme Court says that it's not an intrusive invasion of privacy, considering what you're trying to do. Who's going to pay for it? I don't know. But I promise you this, if you guys give me the will, I'll go out and I'll find somebody that'll help us. Okay? I'll do the legwork on it. I don't mind doing the legwork on it. I just need somebody to talk to give me some guidance from up here. Okay? Where will the money come from? Again, I don't know. I'm not in you guys' business, and all I do is coach a little bit of football and teach a little PE, so I'm not real sure about the workings of all this, okay? Is it worth the cost? If you save one, it's worth the cost, in my opinion. If you just save one. It's like the little kid walking down the beach picking starfish up and throwing him back in. And the guy asked him, what are you doing? He said, oh, I'm throwing starfish back in. Well, it doesn't make any difference. What make difference to that one? So it's worth it to that one. In Sumner County, they've been doing this for years. There are 4 high schools that I know of: Hendersonville, White House, Portland, and Gallatin High School. Gallatin High School may have been the first high school in the state to do this. They've been doing it for nearly 25 years. You guys ever heard anything on TV about them? Because it's become commonplace. When their kids go in for the school year, they sign the piece of paper that they can be randomly drug tested. It's not a big issue anymore. They've gotten past that. They did it 25 years ago. Okay? It works there. It works at other places. Okay? Really what it boils down to is we got to take a stand for our kids. We got to have guts, and we got to make sure that we're doing what we're supposed to do for our kids. What we're all in this business to do, and that is to save lives at some point in time. Educate them, make them great fathers, make them great wives, make them great mothers and fathers, and make them productive citizens in society. And this is the whole part of the deal here. We got to weather the storm. If we decide to do this, we got to weather the storm, and we got to stick next to our guns. And I promise you, if we do that, in time it'll pay off one way or the other. The proposal that I set in front of you, I'll be flat out honest with you. I threw this together and I stole it from a bunch of different places. Okay, I took it from probably 5 or 6 different policies that I saw that might fit our way, that might fit our county. Is it the best way? Is this perfect? No, it's not perfect by any stretch of the imagination. If you put it in front of a lawyer, they're going to rip it to pieces. I understand that. Okay, but it's an idea and it's a starting point. I appreciate you guys' time. Anybody have any questions?
Thank you, Coach.
Thank you guys. I appreciate it.
Terry, what, you have a question or?
Well, I just comment. I mean, I've kind of been there and done that. I taught driver's ed in my time, and we always went through the drug and alcohol unit there. And when you mentioned the rattlesnakes, I think it's a good comparison. It's just teenagers are bulletproof.
Yeah. I mean, they all are. I've got a 19-year-old son, and he thinks that.
So
you know,
but I also want to say that there's a person here in the judicial system that has encouraged us to do this. He's seeing these kind of things with teenagers and whatever, and I'm clearly of the opinion anytime we can give people a reason to behave, but it does fall into the category of, is it good for kids? Yes. Can we afford it? That's got to be the question we got to look at. And when you say to do it and do it the right way, you will need to be able to do it on a fairly consistent and fairly broad-based situation to the point that you actually do catch a few and
I agree, and
make that happen.
And it's not in this plan, but one of the questions is how often you do it and who you do it with. If I was to do it with my team, and I have a drug and alcohol policy with my team, it's automatic. If I catch you, if I find out about it, it's an automatic 2-game suspension. You got to go seek counseling. I have counseling worked out with a counselor who will take care of underprivileged kids for me in my school and my program. If I got somebody that says I don't have the insurance or I can't do it, it's happened twice since I've been the head coach at Siegel. My first year I had one, and then last year I had one. And last year's kid was underprivileged, didn't have any insurance, couldn't afford it. She took him in, she counseled him 2 or 3 sessions. Did it work for the kid? I don't know. I hope it did at some point in time down the line. You know what I'm saying? But that's part of the process that he did, that he had to go through to reinstate himself back with me. How many times do we test? I don't know. Do you test, 2 or 3% of your athletes in each school every month? Do you test? Do you come in and test 2 or 3? My feeling is this: once they know it's out there, it's a deterrent right now. Whether you test 1 or whether you test 10 a week, in my book, that's my opinion. So I think we can look at it in a bunch of different ways, but once they know it's there and that's the possibility, then it's always going to be in the back of their mind.
Wayne?
Does Gallatin test just athletes or all extracurricular?
As far as I know, it's just athletes, but I'm not real sure. I spent very little time on it. He had to run in the middle of our conversation, so I really didn't get into a whole lot of depth with him. But that's something that I'd like to follow up with him and find out about. Yes, sir.
How early do you start this? Middle school?
I know some places they start in 7th, 8th. They go from 7th grade all the way up to seniors to 12th grade. They started in 7th grade there. I know some places are just in high schools. Okay, so I don't know. That's a very good question. Going down to 7th grade, that might be a little bit touchy. I don't know. But if they'll know by the time that they get to you. If you just do it in high school, I think they'll know by the time they get over to you what's coming down the pike with them.
Aaron?
In the years that you've been working with your athletes, have you had those circumstances where there's been an explanation, a medication, those kind of things? How have you been able to work through that, or have you faced it?
I've not run into a situation like that. The 2 that I caught, one of them I was caught stealing beer and his parent turned them into me. The other one walked up at a basketball game high as a kite, and I knew it then, and he admitted to me. But I haven't had a situation where that's come up. But I think that needs to be written in, and I think it's written into the proposal that I handed you guys that once they're tested, they have 48, 72 hours to bring in their note from the doctor that says they're on this medications, and if it shows up, then there's an excuse or there's a reason why that should be there. For instance, my quarterback got his wisdom teeth cut out. Well, I know if I went and tested him today, he's going to have some type of opiate in his system because of the pain medication that he's taking. Well, I take a note from his dentist that says that he's been prescribed this for how long, and that gets him that excuses that positive there.
Sure. Well, thank you, Coach. Terry, what would you like to see us do at this stage?
Really depends on what the committee wants to do.
Well, we're a long way from voting on anything, obviously.
I
mean, there's got to be some sort of...
I did some cost analysis and things too to see what.
There's a lot of research that's got to go into this, and I don't think this is something that can go into effect within the next 2. I'm looking to start it next August if there's a possibility. I know there's no way to going right now, because I know there's so much research and things that's gotta be done, cost analysis and things like that. So, I mean, my ballpark would be great if we could start it next August when they came back to school.
Mr. Odom, can you sort of
Yeah, we can do some of that,
start studying this issue a little bit and?
see what options we
Yeah.
have.
Is there anything that I can do to help?
I don't think at this point, I mean, I've already done some preliminary stuff.
Okay.
Some cost, gathered some costs, and pulled some other policies. I will say that right now, the biggest hurdle that I see would be the cost issue. Most of the systems that I've talked to and have policies are, use them outside the lab.
Yes, ma'am.
Which makes it a lot easier handling that sort of thing.
Yeah, yeah.
They have actually, some of the smaller systems have actually stopped doing the program because they were using Safe Schools money, which is state and federal money that's been cut over the years.
Right.
So, I mean, that's something, certainly something we have to look at. You also have to look at, the Tennessee law says that you can reasonable suspicion screen any student. You can randomly screen anybody involved in extracurricular activity, so you have to look at what groups you want to look at, how often you want to do it, if you're going to do reasonable suspicion, what would that be? And, you know, it just is going to take a lot of planning.
Yes,
If
ma'am.
it's something that we want to do.
Okay, well, if you all will start looking at that and then come back to us when you have some results.
We'll look at some other policies, see what's been done. I mean, we're not reinventing the wheel. We need to see what's working and what pitfalls might be there. Okay.
If you ever need anything from me, please feel free to call, because
Thank
like I
you for
said,
bringing
I'll be glad to put legs on it and help you out any way possible, okay? What I appreciate is you guys listening to me, all right? Thank you very much, guys.
Well, let me add to this. It is refreshing to see someone come with a problem that offers a solution, because oftentimes we get problems without a hint of where the solution needs to lie.
That's
So
what
I
tell my
compliment you for
coaches.
that.
Don't bring me a problem, bring me solutions.
Thank you.
All right, thank you, Coach.
Thank you, guys, I
Thank
appreciate your time.
Okay, we'll go back to.
Number one, yeah.
On the agenda, which is policy 1.400, school board meetings. The first, about 5 policies on the agenda tonight are actually on the agenda because of legislative changes. So what you will see in the underlying portions of these first 2 policies are things that have been changed in the law. So we needed to add to our policies. I have X'd out, you can see regular meetings, that section, because this is TSBA's policy. That portion of the policy is not in our policy, so I X'd that out. What would be added is starting at the bottom of the page there, electronic attendance. And as most of you probably know from the TSBA law conference, they've added some sections in the law that allow board members to participate electronically in certain circumstances. There are a lot of limitations, but all of those are listed in the new policy.
Okay.
Do we want to just move it down those without voting on each one, since they're
let's
pretty much
do-
statutory?
At least 1
Do you-
through 5 are all
That's what it is,
legislative
yeah.
changes.
That'd be fine.
Okay, number 2 is 1.704, charter schools. And the same thing with this one, there have been some changes in the law with respect to charter schools. Under the application process, you'll see that they've changed the notice that they have to provide us with. The application has to be in 60 days prior to the deadline, which was 30 days. Mr. Odom and I talked about this one. We also decided that they have to send it certified mail to be listed as a receipt
Yeah.
for that. And then on the second page, you can see they've changed the dates for the application deadline. There is also an application fee of $500 now. It was not in the old law. Mr. Odom also thought that it would be a good idea to require them to submit 3 copies of the application because they're potentially hundreds of pages long, so that we don't have to do the copying when we get them in. So we added that. Down towards the end of that page, line 39, that gives you some direction about when you have to act on the application within 90 days after it's submitted, or it will be deemed approved. The next page, down towards the bottom, also instead of 15 days to deny or approve, you now have 30 days. And then the last sentence there, denial of application for new schools form to address local performance, that section has been deleted. And all those are legislative changes, so not really having to put it out.
So can we add the legislative changes? Like you're adding certified mail stipulation?
Yeah, I
We
checked
can-
with TSBA, and they said they thought that would be fine.
They actually recommended some of these things at the law conference, if you remember. 3 copies, that was recommended there. If you don't, you have to have
Yeah.
an expense.
Okay. Any
As
questions?
long
on
as we
that?
don't change the deadline, we can do it.
Okay. Any questions on that one? Okay,
Okay, and we can sort of look at 3 and 4 together. There are separation practices for tenured teachers and non-tenured teachers. And the changes in that first paragraph, as most of you know, if you suspended a teacher, they were entitled, suspended or dismissed, but this handles the suspension, they were entitled to a hearing before an independent hearing officer. This now allows the director of schools to suspend for less than 3 days. They don't have the right to that hearing any longer before a hearing officer. They have a right to a meeting with the director of schools, and then he has to render a decision. So this adds that change. And that's for both tenured and non-tenured teachers.
okay, questions on those? 5?
Okay, number 5.803 is evaluation of the director of schools. And again, this is a legislative change, and you can see the underlined portion that they've added. It says that performance objectives will be memorialized in an evaluation plan that includes at a minimum sections regarding job performance, student achievement, relationships with staff and personnel, relationships with board members, and relationships with the community, which I think is already in what TSBA has talked to you guys about in terms of evaluation, but it's required.
Okay. And our new evaluation will meet these standards, right?
The TSBA designed it, so we would
Yeah.
hope so.
We would hope. We would ask for our money back.
Okay, so all of those, do you want to go ahead and vote on those?
Yeah, let's do.
Move to approve.
I'll second that.
Any discussion on any of those 5? So the motion's to approve 1 through 5. All in favor of the motion, say aye. Aye. Opposed, say no. Motion's adopted. Number 6.
Okay, number 6 is 6.204, and this is the non-resident students policy that we talked about at the board meeting last week. So if you look down towards the bottom of the first page, where it had said in the past, underline 17, it said the children of teachers of the Board of Education that reside outside the county may attend Rosebud County schools. I've changed that to employees. Number 1 has been added,
Is that,
that was not in the old policy,
that's okay.
so that all requests will be considered based on available space in the requested school zone. We have deleted section, what was section 2, that talks about charging tuition, which we don't do anymore anyway, so that really should have been deleted before. Number 3, instead of teacher, we've changed it to non-resident employee. And then number 5, this is a section that we had in our administrative procedure about classified employee zone exemptions. And I added this just for your consideration, that if an exemption is granted for the child or children of classified employees, the employee must reapply annually so their continued employment in schools and zones can be concerned. We put that in our administrative procedure because classified employees tend to move around. They turn over more rapidly and quickly than teachers do. So just to verify that they're actually still at the same school the following year, so the children can stay at the school. So that's just for your consideration if you want to leave that in there. Otherwise, the change has been to change teacher to employee.
I think that last one was a good idea.
Are we still okay if we've got a instructor that might be floating between schools? Is there some provision there that we can include? Because I know we do have some instructors that are at multiple locations.
I think we consider that. James deals with those.
Yeah, on that one, I'm talking in county only now. There are not a ton of those, especially who qualify because we had a county, but we tend to try to look to see if there's one location they serve more. So for example, if they're split between 2 schools and they work at one school a majority of the time, 3 or 4 days or something like that, that's kind of the one we use as their home base.
Okay.
But we work with them in that situation based on their specific needs,
Okay.
kind of case by case.
other questions?
I have a concern that I think needs to be considered. Classified personnel do float around and are, hired at the whim and so forth. I'm concerned, especially at the high school level, that you've got the possibility of getting athletes recruited to that kind of a situation, or parents hired based upon the fact that they've got an athlete and they want that athlete to go to the school. I think that's something we need to give some consideration to, because that could certainly be an abuse of of the term there. And my recommendation would be if they are granted that they would be ineligible to play athletics at that school.
I think that's a good, I'm surprised we didn't think about that.
Well,
I'm glad you
too,
raised that.
yeah.
That could really open a can of
But
worms,
can we,
couldn't it?
can we do that? I mean, can we,
It's an exemption anyway, so it's up to the parent to
Oh,
choose
okay.
whether or not to take it.
that's great, that's a great idea,
Yeah,
I've
that's very good.
yeah.
been victimized by that before.
Another thing in our discussion the other night, just as part of the discussion, mentioned bus drivers, but bus drivers now are not employees.
Right.
They're contractors, so just based on the discussion the other night, that would not include that particular group.
With regard to the athletes, where is the provision that allows for, you know, an employee that has been there and their grade schooler came all the way up through? That person's still gonna be able to participate, right?
I would say no.
No, I don't think
Really?
so.
So if the employee had been at the high school and their child had been going to the elementary, then the junior high, and then to that high school, can't participate in the high school athletics?
But they
You know,
wouldn't-
I haven't thought it that far through. I mean, if you.
Well, they can't work at all three schools though, can they? I mean, they wouldn't, it's
But
not,
they would be entitled to go to any school in that zone. They work at Blackman High School and their child is elementary, they could go to Blackman Elementary.
oh, okay, somehow I missed that.
You know, I hadn't thought
That's
that
the
far
way-
back. You know, if you got a situation where somebody's been kindergarten on through and so forth, they're based. If we can work the language out on that, I think we just need to be aware that, you know, a 10th grade athlete, suddenly his mama ends up working the cafeteria line, and then the next one, you got 3 or 4. It can clearly happen. So
Yeah.
that's the safeguard I'm looking at, how far to go back, whether historically you can make that work, and we're willing to go that direction. I don't know. Mr. Counselor's going to weigh in here.
Well, I don't know, if you want to make them ineligible unless they've been in that school zone for, say, 2 years or 3 years or more, you can put some time limitation on it. So that will keep people from recruiting and having someone available for athletics immediately in the next school year. Whether you make that 2 years or 3 years out, or 4 years even, you know, that's a discretionary call.
Why make it so difficult? Why not just, I mean, it's an extracurricular activity. So why do you want to, you know, make 2 or 3 or 4 years and make it hard to account for? Just say,
Say no.
if you want, just say no. And if they want to come, fine. If they don't,
Well,
they can stay in
I'm
their
gonna
zones.
take the other side of that, and this is my own.
You're arguing
I'm
against
gonna vote
yourself
against
now.
myself. You know, and I can clearly see you've got a secretary that's worked at the school for 22 years, and you know, and the son has worked their way up the system. They're not working the system at all, and suddenly you're going to penalize the athlete at that point in time by not letting them play at a school where they have every reason to, in my view. Where I'm concerned, I'm just concerned about suddenly this really good 10th grade player landing at someplace because of that ability and the hiring practice.
If it helps at all, TWSA does have a small safeguard there that helps for at least a year. If you already have an established athletic record at either middle school or high school, and then you get a zone exemption to go to a different school, you are ineligible for 1 year. It only helps for 1 year, but that's in county, out of county, anywhere. If you get a zone exemption, if you don't have a legitimate change of residence, you change schools, you have to sit out for 1 year. Now, they got it though as a 9th grader.
Sure.
They would not have an athletic record for that high school, and so they would be eligible immediately. Are you saying that you would only want to do this potentially for the classified portion or for all?
No.
of those?
This would.
We don't have any the reason I asked that is we don't have any restrictions now for certified teachers who
You know,
are hired to come in.
and that's been in place, and that's historically difficult to do because the teacher's typically not going to move. I'm just saying it's easy for a principal at this day and time to hire into that kind of thing, and I just try to protect against that kind of abuse being in place. I mean, I'd be fine with a situation where if there's some sort of a record of attendance that's already in place, and whatever.
Sure makes it hard on the staff for accountability, though, you know, just something else to keep up with.
It will happen very rarely. I mean, that's the thing. It's not like you got to keep up with a whole lot of this kind of thing.
We're pretty competitive in this county.
You see a kindergartner with potential, you go ahead and get a job.
Well, I'm not like Coach White, I didn't come with a full solution. I had a solution until he knocked it down. But I think, I agree with that. I would hate to see the athlete penalized the other direction that has been part of that system for 8 years, and suddenly they get to high school, they suddenly now have to go to their school of zone or not be eligible to play. I don't think that'd be fair either. So I'm in agreement with what you're saying.
Let's lean on the TSSAA, 1 year exemption then, and keep an eye on it.
I would be for that, which would then, if we put it as part of our policy, that does catch the incoming freshmen as well. What you're saying, you're right, 10 through 12 gets that. Most people are not gonna give up a year.
Yeah, it would apply to your sixth graders if they're coming, or, with their first year of middle school and their first year of high school, if you want to add that to what you're saying. I'm pretty sure it does, that it's similar in middle school.
So what do you want to add? That
I would just, I would be in agreement with that the student would be ineligible for 1 year from the time of hire. Does that make sense?
So they can't come in April and be eligible in August.
Correct.
So for 1 year from the time the exemption is granted, 1 school year?
That'd be fine with me.
If I could ask, just for clarification.
Please.
The situation we had that prompted this discussion at Laverne Lake Elementary, when her child gets to middle school, she'll have to reapply for a new exemption because they're changing schools. So would that child then also be ineligible for the first year of middle school and the first year of high school? Or because she had gotten an elementary school? That's what I want. What are your intentions there?
My intent there, I think, would be that if they're in the pipeline, they would not have to get they would not have to wait that second year.
You're talking about new hire. He's talking about new hire coming in.
Okay, that makes it easier.
Correct. Yeah, that's exactly right. It's new hire coming in, period.
So it would be from their initial application, from the time their initial application is turned in.
For all schools within that
Okay.
zone. To apply within all those.
Made that one hard, Tim.
I'm sorry?
You made that one hard.
I know it. I live to be that way.
Well, we need a motion. Do you want to move to approve and,
I'll move whatever Angel, if she'll read it to us, what she's got.
well, we need, approve the recommendation with the amendment.
With the amendment that says the student would be ineligible to play athletics for 1 school year from the time their initial zone exemption application is granted.
So they could move as a freshman and play as a junior under your scenario?
If they move during freshman year, they can play as a sophomore. Yeah. If the zone exemption was granted July the 30th, if it's granted today, they come into the freshman year, they would not be eligible to play this year. They could play next year.
So the coach would just have to wait, or the principal, whoever's doing this scheme, would just wait 1 year and then they'd get.
Yeah,
I like
that
the first
year is
version way
pretty
better.
critical, though, I have to admit.
Pardon?
That year is critical.
Well, if you had a 9th grader who had played at a previous school and then got a zone exemption to come in 10th grade, they would be ineligible for the first year because of TSSAA.
Right.
What you would catch is someone who's coming in at the 9th grade who had no playing record. So you would hinder them that first year.
I mean, I don't know how likely it is a family would want to do that. I mean, to take a year off just to play at a certain school. I mean, is that you've got the experience?
I think
Is that
it's,
likely?
for me, it's enough of a deterrent to think that we would not see a lot of abuse.
And Mr. Tackett, you want this for classified only, coming from out of county, is that what I understood?
The classified is the only place where I think that you're going to see the problem, frankly. I mean,
I just want to make sure I understand you, so
I don't know that a principal's necessarily going to go out and hire a teacher based upon that, but I think they certainly would go hire someone on the classified side. That's where I would see the abuse.
And that's the reason we put in that they have to reapply annually because of that type of thing anyway, so I think we agree.
Okay. I think that was a motion. Are you seconding or you have let me get a second before we discuss.
I'll second.
Find time for me to develop parliamentary procedure.
Yeah.
Now, Mina, go ahead.
So I'm trying to follow, make sure I got it. The parents gets hired at the school. And the time it's
Only if he's moving or she's moving from their zone school to the school with a parent.
Yeah, they can, if they want to
Stay at their zone
participate in
school.
athletics, they can stay at the zone school and play. I mean, it's a
Well,
choice.
this only applies to students who are out of
Out of
county.
Out of county, right.
So it's even more limited group of people.
Yeah, right.
Thanks for the clarification. Out of town.
So to muddy the waters even further, right now, if you're a classified employee and can you bring a child to, you live in the county, can you take your child out of zone to whatever school you want? You can, can't you?
Yes.
So why isn't, I mean, to me, that's the same situation you're talking about. If you're talking about recruiting,
But the
They can do it
TSSAA
now.
restrictions.
They still have 1
in
year.
force.
Right, but I mean, you still wouldn't have that if you have a incoming ninth grader who has no established
Okay.
playing record.
I'm sorry, I missed part of the conversation. Okay. I got you.
So if I'm correct, though, this is only applicable classified out of county.
Out of county.
Okay.
Just what we're
Yeah, I'm sorry, I got
dealing
it.
with tonight,
Yeah,
yes.
I'm sorry, I forgot the out-of-county part of it.
How do coaches know that you've got an Allen County student here under exemption? Do they get this at the beginning of the year saying,
Before athletes are allowed to try out, they are supposed to produce a proof of residence, which would typically be a utility bill, or if they're on a zone exemption, they have to present their approved letter that says they're on a zone exemption.
She said that she talked with your folks today and before, and
and that's
that
something
they just come
we
in.
routinely check? Do we check that in schools?
They have to, yeah, they sign it and say yes or no, accepting or rejecting. Actually, from in-system, it's both principals.
Be asked tonight, so.
Out of county would be one signature.
And then coaches will then have access to that information,
Well, the principal would have the burden of providing that.
to the coach. So does that happen, is my question? Do principals routinely give that to coaches or not?
They're supposed to.
It is supposed to happen.
The other thing is, the coaches have to submit a form to TSSAA to make sure any new student that comes to their program has to be approved by TSSAA.
Does that form have places on exemptions?
It talks about it's pretty in-depth about how that student ended up at that student. It's pretty.
It does have some questions about, was there a residence change, or what reason was there a custody change? I mean, we've dealt with something like that before, so it's a pretty thorough process.
Very, very thorough from the TSSAA side on eligibility. Yes.
Okay, we all clear on the motion? Any other questions? All in favor of the motion, say aye. Aye. Opposed, say no. Motion's adopted.
Okay, the next one is school nutrition management, 0.500. And the change to this one is on the second page, where you can see that we have added under the charge policy that per federal guidelines, no charges are permitted for all cart items under elementary and middle school. And that is, it's been that way, and we've not permitted them, because it's not been written in policy. We had a parent question that last year, so we thought it was a good idea to add that in policy.
Is that like ice cream and stuff like that? They're not charging broccoli and stuff like that. Any questions on that one? Okay, the motion would be awesome.
So moved. Second.
Discussion? All in favor of the motion, say aye.
Aye.
Opposed, say no. Motion's adopted.
Okay, the next one is 5.117, procedure for granting tenure. This is one that we missed in last year's overhaul for legislative changes. And as you all remember, there were great changes last year to the tenure law and to collective bargaining, all kinds of things, but we did not update our tenure policy last year. And so when we're going through sorting out which ones needed to be amended this year, Joe Mosley and I came across this one that had not been updated from last year. So this incorporates the legislative changes from last year into our tenure policy.
Why was it not updated though? Was this oversight?
Yeah, it was just an oversight. I think when they sent out their legislative updates last year, this would have been in the packet that they sent, so it didn't get which Steve updated, so.
It was actually in the middle of the legislative session, part of this was going on too, when they were making the changes.
Okay, motion,
Move to approve.
second. Any discussion? All in favor of the motion, say aye.
Aye.
Opposed, say no. Motion is adopted. Number 9.
Okay, number 9 is student wellness, and what I have given you here, the top 2 pages are the revised policy, the last 2 pages are our current policy. Again, there were some changes in state regulations regarding student wellness and coordinated school health. I couldn't really mark the changes in this one because it's really essentially a brand new policy. So because of all of the regulation changes, the requirement for coordinated school health screenings, the School Health Advisory Council, TSBA just sort of revamped their policy to one that complies with all of the new regulations. Our coordinated school health person says that we are pretty much in compliance with all these already. So it won't be any great changes, but regulations now require the things that they've added.
Did we have the 90 minutes a week, physical activity week? Is that in the old policy, or we're doing that, aren't we?
I don't think the specific 90 minutes is in the old one.
But did the state specify that?
Yes.
Seems like.
It wasn't all physical education, it could be playground time, could actually be walking around.
Walking from math to science?
Well,
Did you try that?
if it's organized.
Oh, okay. Okay, good.
Further defined.
I'll need a minute to read the new policy, or are you ready to? Somebody make a motion, please.
I'll move we approve.
Second.
Any discussion?
I did.
All in favor of the motion, say aye.
Aye.
Opposed, say no. Motion's adopted.
6.316, suspension, expulsion, remand. Again, this is a legislative change. Number 9, they now require that this be added to your suspension procedures assaulting a principal, teacher, school bus driver, or other school personnel with vulgar, obscene, or threatening language. And we had all of that in there up until with vulgar, obscene, or threatening language, so that's what we added. And then on the next page, number 15, wearing while on the grounds of a public school building during regular school day clothing that exposes underwear or body parts in an indecent manner that disrupts the learning environment. That's the one that started out to make, the legislation was to make it against the law.
The saggy pants.
Saggy pants.
And when it finished, it was that school systems had to adopt policy to discipline for sagging pants.
So moved.
Second.
Any discussion? There's also sorts of jokes there, but I guess we'll just forego them. All in favor of the motion, say aye.
Aye.
Opposed, say no. Motion's adopted. Number, 11.
6.702, student clubs and organizations. And this one is on the agenda from request from Mr. Holiday, and I sent everybody a draft that he sent for you guys to look at.
Aaron, do you want to explain your thinking here?
As student organizations are an extension of the academic curriculum, I thought about the academic curriculum and the fact that we approved all of the academic courses that are offered in a Rutherford County school as a board. And the student organizations are approved by the standing policy by the individual principal. It seemed to me to be an inordinately large responsibility to put the student organization approval on the principal, particularly when it's in the light of federal precedent that says that we cannot deny student organizations. We can only make the decision that we have student organizations or that we not have student organizations. In many ways, a principal is in a position that if there is a Rutherford County employee sponsor and a couple of pieces of paperwork filled out, then they are somewhat obligated to approve that student organization. I felt like it would be appropriate for that approval process, pardon me, to occur at the board level. Not to deny any student organization from existence, but to approve the characteristics and the boundaries that that student organization would exist in. So the policy that I have proposed does that.
Did I hear you say you wouldn't deny any organizations? 'Cause if that's
As
the
it's
case,
been explained to me by legal counsel, when it comes to student organizations, our stance is only to allow them or not allow them. But to dictate which particular student organizations are allowed is something that federal case law has already rendered a decision on. And so in that respect, I think we would be challenged to say no to a student organization, their very existence. However, I think it's well within the board's discretion to give certain guidelines for how that organization would exist. It can exist, but it exists with these stipulations. For instance, is that we may find the Fellowship of Christian Athletes, a worthy student organization that comes with a Rutherford County employee sponsor and is presented to the board. We could approve it for 9th grade and above, in the same way that we approve a biology course that's taught at 9th grade or above. It has certain things in it that are appropriate for that age level. At elementary school, the Fellowship of Christian Athletes just doesn't exactly apply. That particular organization may or may not be applicable to junior high, and I think that that would be appropriately debated and decided. Similarly, we would have the requirement that in this presentation to the board, any civic organizations or outside interests that might be supportive of this student organization through funding or curriculum would be considered by the board. I've used the example in conversations with friends that if the Daughters of the American Revolution, a worthy civic organization, wanted to have a student chapter at a local high school, and they came and presented to the board, but in that presentation, they disclosed to us that they were going to use a curriculum that had been provided to them by the Montana militia, the board might say, we don't feel like that's an appropriate curriculum. We're not saying you can't exist, you just can't use that curriculum. And it gives the light of day, it gives public disclosure, and it gives the community, and the community's representatives are the school board members, it gives the community a voice in what social organizations would exist in the area of complementing the academic curriculum. I think it's an appropriate and important policy shift that, again, encumbers us a little bit at the beginning, because I would not grandfather any organization in, and we would have a sizable task to consider all of the student organizations that are presently here, for this first year, and then move forward beyond that. But I think it's very, very important, as we don't know what's on the horizon and what student organizations may come to our system, that we be appropriately prepared.
Okay. Is that a motion?
I would move for the adoption of the
proposed policy change.
Is there a second? I don't hear one. So,
It's just too complicated to take it up with this no warning on this. I think a lot of if, ands, and buts are there, you put in there, and a lot of conditions. I think we need to.
Mr. Holliday, has
Take
Mr.
time.
Reed been involved? I'm sorry.
no, I'm just gonna say, if there's no second, we don't need to continue the
I
discussion,
understand.
really.
I just want to explain why I didn't second
Okay,
or consider it at all.
yeah. Yeah, so it dies for lack of a second. Now, Wayne, sorry, didn't.
Okay, so, Mr. Holliday, did you bring this to Mr. Reed for his review?
In March, we sent that,
Is
yeah,
it
sent that
appropriate
out.
for Mr. Reed to give an opinion? That, I mean, just because it died doesn't mean that it can't be brought back, you know?
Well, I can comment on it. I think philosophically, you've got the broad question, first off, whether the board philosophically wants to just make it a policy of the board for the board to approve all student organizations within a school. That would be a shift fundamentally from how it's happening now, because obviously the school principal has the discretion with respect to all school organizations and clubs under our current policy to decide what exists within their particular school. So I think if the Board of Education wanted to go that route, you first have to kind of have a broad decision whether or not the Board of Education wanted to pass and approve those clubs and organizations within the school or not. That's the broad issue. The more difficult issue is, well, if indeed it's going to come to the Board of Education, and under what parameters are those requests going to be brought to the board, and what requirements are you going to impose upon the individuals making presentations to the board to get approval for their organizations. And in that context, obviously you have to treat everyone, all the different groups equally and the same. And you have to be careful to not discriminate and act unlawfully under federal constitutional principles with respect to various organizations, with respect to the activities they are requesting to present. You're going to have probably some activities with religious, such as the Fellowship of Christian Athletes, which comes out of Christianity and Christian undertones. You could have Muslim organizations. You could have other various religious organizations come to request approval. You also have different orientations. There's a mass thing, a group of clubs and organizations that could have constitutional issues with respect to the matters they bring before the board, with respect to whether or not the board has even the discretion to deny or approve that particular club or organization. So if it comes before the board, then at that point, then the board will be faced with the decision, well, it may not be able to deny the application itself, but what restrictions will we impose upon a particular organization? And that's really going to be a case-by-case situation with respect to how far the board can go as far as implementing specific rules or restrictions on the activities of the club or organization within a particular school. And that gets into the kind of more detail-oriented part of it. Obviously, if we started this today and brought all clubs and organizations before the board for approval, that would be a pretty significant undertaking, as Mr. Holliday suggests. I mean, that would be a major undertaking. If the board was inclined to go this direction to test it out, the board might want to try it with maybe elementary schools or junior high organizations. I have not floated that to Mr. Holliday, but that may be something you could test it out and kind of see how the policy works in the elementary and middle school sense first before having it be applicable to the high school that has so many different clubs and organizations. Because within a high school, you've got far more clubs and organizations than you do have in an elementary school or in a middle school. So that might be an option, to kind of weigh into it and see what direction the board wants to go with it. That's another, whether that would be what Mr. Holliday would want, I don't know, but it's something that could be considered. Is correct. With respect to, I think Mr. Holliday spoken with other legal counsel of the state, I believe at some point, did you not?
I did.
And I think the state opinion on it was that you can decide whether you have organizations or not, but you can't really dictate to those clubs and organizations what their purpose is. Or in so many words. So you're somewhat limited with respect to what you can do legally in that matter. So I think first, you know, if the board wants to have this discussion, if there's, certainly, clubs and organizations are an important part of our school, so it's an important issue to look at. And Mr. Holloway is correct to point out the fact that, clubs and organizations could be misused in particular situations to maybe negatively influence our students. And, and not all student organizations or clubs necessarily may be good. So, I mean, you probably don't want malicious organizing within your schools, things like that. So there are definitely some concerns with respect to some student clubs and organizations that could arise. But right now, those are being handled at the school level by the school principal, and whether you want to shift that to the Board of Education is, I guess, the first decision the board needs to face. Whether you think that's more appropriate to be made by the board, or is it more appropriate to be made at school level by the individual principal?
The opportunity for a mistake or the opportunity for personal discretion when it is decided at the individual principal level, just a misstep, an inadvertent decision that may leave the county in a legally precarious position. The public disclosure has certain advantages for protecting the county.
Terry?
I guess my question would be, as far as principals go, what their feelings would be on this. Mr. Tackett, he's former principal, Mr. Horn.
Well, that'd be the question. That's the question filtering through my mind. Are we trying to solve a problem that's not a problem? And that's kind of where I would be. I was in that position. It was never an issue with me. I have not had a principal say it's an issue with them. I think we trust our principals to do lots of things, I just don't see. I'm not aware that there's a problem that needs to be done. I think the way it's worked has worked, continues to work. Mr. Horn can speak to that as well. I just don't know that we need to take on a problem here at the board level that's not there. If a principal has an issue with a club, then they're going to contact Angels. They may contact board members and say, I've got this issue with this club. What do we do? I would hope they would have that ability to make that decision. That's a decision that has lots of time to be dealt with. It's not like the quick decision you got to make when somebody's got a gun on campus. What are you going to do? If we trust them to make those kinds of decisions, surely we can trust them to make the decisions on how they're going to handle a club. So I'm not aware there's a problem. So I'm not particularly in favor of changing something that seems to be working right now.
I think, please.
I was just going to say, to my knowledge, I'm not aware of a problem out there. But having said that, some of your very thoughts about down the road, I'm sure at some point we'll probably have to address it. So, I've got some concerns about groups that might want to start clubs and stuff. So there's that balance act. Are we going to continue having clubs, or is it going to be kind of going the way of like booster clubs? Are we going to have them or not? So.
I'm just going to go back and say it's not a matter whether they're dealt with or not. It's just a matter of who's dealing with them. And right now, the principals are dealing with them, and I think effectively dealing with them. I wouldn't change that. Those problems are going to come. If they can't come, I know very well the types of organizations that we would rather not be part of the situation. But whether the principal or the board makes that decision, I don't think it's going to circumvent whether they're going to come to us with those kinds of requests or not.
If the board makes that decision in a policy that we consider today, then we make it proactively on our terms as opposed to making it reactively with potentially the consequences of a decision that's been made by one individual principal that may tie our hands. For us to act ahead of a situation, you're right, we're fortunate. We don't have a problem. But do we anticipate that those concerns may arise? If we act today, then we act prudently and appropriately ahead of the concern. If we act when there is a concern, then we face the scrutiny of we're picking on that individual organization. When we put a policy in place ahead of that, then we put a policy in place for all organizations to stand up to.
But I thought the legal thinking was that we're not allowed, we can say we have clubs or we don't have clubs, but we can't say we can have this club and not that club. Is that what I heard you all say?
But we can restrict the terms under which that club exists.
Well, I don't know what that means.
The GLBA, the Gay, Lesbian, Bisexual Association, the board may decide that it can only exist at 9th grade and above. Or we can have no policy and a middle school principal may find that a GLBA organization would like to gather in a middle school in Rutherford County. And what would that principal be permitted to say other than, do you have a Rutherford County employee sponsor? I'd like to offer that principal the protection of, have you gone to the school board and stood in the public square and made your case for your organization and heard the decision? We're not denying that the club exists in Rutherford County, but we are saying that there's an appropriate and correct age at which it is a complement to our academic curriculum.
So we can say that from a legal standpoint, apparently, or we don't know for sure because it hasn't been adjudicated.
I don't think you can. I mean, if those kinds of restrictions are not put on other clubs at middle school, then you couldn't impose that restriction on that particular club.
But to me, short of making a list of these clubs are approved and these are over here are not, I don't know what, I'm not
The
sure.
list is exactly what I'm proposing we do.
Well, I'm dead set against that.
Do we have a second?
No, I mean, this is all sort of pointless discussion, not pointless, but we're not gonna act tonight. I mean, Aaron, you would need to come back with something else. Or you can come back with this again if you want, but I mean, it's, in terms of action tonight, we're not taking any. So, anything else on this issue?
It's disappointing that we would not be ahead of a concern that we might anticipate.
I'd say it's disappointing that we don't trust our principals to do their job.
I'm only interested in giving them protection and allowing them to do their job.
Have they asked for it?
It doesn't change their approval.
Have they asked for it?
No.
Okay.
Let me ask a question. How long has this existed, this discussion? How long has it been, for a number of weeks? Or this first I've heard of anything remotely related to this. Is this something that just came up to you from somebody? Or
It's
just
my concern.
Well, I mean, they're saying it's, you know, we've had a lot of discussion here, something that just came up, we should have given us a little more warning and a little more information ahead of time for us to look into it. I don't know.
Well, for right now, let's move on to number 12.
Number 12 is 4.700 testing programs, and down at the bottom of the page is what we've changed. Student scores on the TCAP program, grades kindergarten through, and that should be 5. Is that right?
It is.
Should be 5. Kindergarten through 5 shall comprise 20% of the student's final grade.
It's actually,
Is it 3 through 5?
it's actually 3 through 5 now. Now, the state's about to, I'm not sure we don't simply need to say per state
Yeah.
guidelines
Yeah,
rather
when
than
they change it again
expand this
next year.
because they're talking
Rather
about,
than put the percentages?
Yeah.
I mean, the board does not have a right to change high school because that was dictated by the state board. I mean, that is 25%. But you had the choice, which we brought to you, between 15 and 25 for the 3 through 8, if you remember. And the middle school wanted to go at the high school, so that we set that at 25 and then set at 20 the elementary. But you have that authority based on state board criteria. So it may be simpler not to write it out. We can put it in administrative procedure, what the board's vote happens to be.
Okay, so then we would say student scores on Tennessee Comprehensive Assessment Program and in a course assessments shall comprise a percentage of the student's final grade as approved by the Tennessee State Board of Education criteria.
I like that
Rather than
statement.
with
I mean, we
I
do
think
know
it's
we do know what high school is, but,
Yeah,
And that way we would have to change it.
right.
yeah, that's a good idea. Everybody okay with that? Someone want to make a motion?
Move to approve.
Second. Any discussion? All in favor of the motion, say aye.
Aye.
Opposed, say no. Motion is adopted. 13.
13 is a new policy, 6.4081, safe relocation of students. Again, this is a legislative change, and school systems are required to adopt a policy in compliance with the law. Essentially, as you read in the first line, employees who are directly responsible for a student's education or who otherwise interact within the scope of their assigned duties may relocate a student from the student's present location to another location when such relocation is necessary for the student's safety or safety of others. Gives them the ability to intervene in a physical altercation. And then it also, as you go on down, gives them the ability to use reasonable or justifiable force as required to remove the student until law enforcement or other officials come to help with that. So again, it's not anything we really have a choice about. It's something that the legislature changed. And
Well, and we've been doing this anyway, right? I mean, that sounds, right?
say we've actually advised teachers to move students physically, but yeah, I mean, as far as intervening in bodies
Right,
and
yeah, I
those
mean,
kinds
they've
of
always,
things.
So move.
thank you. Ms. Warren, second? Am I reading your mind correctly?
Oh, yes, sir.
All right, good.
Good
I
policy.
think that we were told at the legal conference that this was some protection for employees,
Yeah.
that they might not be afraid to actually step in to try to keep somebody from getting harmed.
Right.
If they could. This gives them some statutory
When they've been afraid.
protection,
Yeah.
yes.
All in favor of the motion, say aye. Aye. Opposed, say no. Motion is adopted. 14.
Okay, 14 is 6.405, medicines, and this is on the agenda tonight because our nursing supervisor here asked that we look at making a change to this policy. Generally, when students have to take medication at school, the parent or guardian has to come in and sign the medicine in. You know, they keep some at the school. They've run into a problem apparently with eye drops, ear drops, and creams because it can't be divided into bottles. So what was happening was the parent would have to come in and sign that medicine in. Child needed to take the medicine home that night to use it because it couldn't be divided up. Parent would have to come back the following day to sign it in again. So this makes an
That's
exception
crazy.
for that. So once they've initially signed it in, the nurse then would be able to release it to the student that afternoon, and they will bring it back in as long as it's the same prescription the following day, for as long as they need to continue to use it.
So moved.
Second.
Makes sense to the principals. All in favor of the motion, say aye.
Aye.
Opposed, say no. Motion is adopted. Is there any other business?
Mr. Chairman,
Yes, sir.
Mrs., I can think, I forgot her name.
Later.
Slater has been patiently waiting, and I know this is out of order, but she's wanting to discuss the situation with the bus contract. And I told her, and you told me it was out of order to do it, but anyway, I guess you
It's not
might
gonna
want
stop
to
you.
be a little bit more official than the way I handle it, but
Yeah.
but here's what happened, is she has talked to several folks, including several folks' secretary, and they said for her to come on up. So it's, you know, kind of puts you in an awkward position as to who has authority to say yea or nay.
Let me just say, I recommended that we not do this because Mr. Snell is not here and he would be involved in this discussion. There's nothing on the agenda involving a bus contract. I mean, generally, I'm all for letting people speak, and especially when they take the time to come up here, but on this issue at this time, to me, it's not appropriate, but I told Grant if he wants to, you know, make a motion to suspend the rules, that's.
Well, I
fine
would
with me.
need some parameters, I think, but I don't know exactly.
Yeah, well, let's hear from
Well, I was
Angel.
gonna say, I think I can probably summarize why she's here and get us to the next level, probably.
Okay.
She spoke at a previous board meeting
Right.
about making a change to the last list of contractors and how it is compiled.
Right,
And what we talked about prior to coming to that meeting is it actually needs to be on an agenda for a policy committee for us to
Oh,
consider
okay.
that. So what we need to do is to add that to the next policy
Okay.
committee meeting.
I
If the board-
misunderstood. Okay,
If the policy committee wants to consider it, then I could have Mr. Snell here and we can,
okay.
you know, and she can come on that.
Then all we need is a board member to ask, or
Right.
a committee member to ask for it to be included. That's an easy.
Is it in the contract or the policy?
It's in policy now.
Okay.
Yeah, it used to be in the contract,
Okay.
it's in policy now.
Well, in that case, Ms., that was,
I think that's
what you want to
right.
speak?
Can I ask for that to be on the next policy meeting? How would I need to do it?
Just someone on this board will have to ask, but I'm sensing somebody surely
Well,
will.
I'm afraid that what he's saying is correct, that we just didn't have information ahead enough.
Right, I understand.
Be on the next one, not on.
Yes,
So
sir.
when is the next policy meeting?
Well, it's not-
That's what I was gonna.
It's not scheduled, I don't think, is
It's
it?
not scheduled yet, but, I mean, we will have another one at some time during the school year, obviously. You know, and we're not really in a rush because.
The webpage, I think, said August.
Well, this
said-
one was scheduled for August
This
before,
is
and
it.
it was
Gotcha.
canceled and rescheduled.
Okay,
So, you know, we wouldn't compile that list
Right.
until over the summer, so we have some time to do that
Yeah.
if we want to.
so it'll be this school year?
Yeah, we'll definitely have another.
We just meet as needed, so unlike regular meetings that are more or less on a routine schedule, policy committee meets three times a year, just sort of as needed, but Ms. McLeod will,
Put
I'm
it on
offering
the next
for you to
agenda?
yeah.
Yeah,
What-
I'll
what-
keep you informed.
We'll
Okay.
put it on the next policy
But
committee.
that's, you know, what I was told when I addressed the board, that it would be addressed at this policy meeting. You all, several of you shook your head, and so it will be on the next agenda.
We said that
Yes, sir.
at a meeting?
Well, I think
Yes, sir.
what you said was that, a member would have to request that it be on the agenda.
Okay.
And then you would, that.
Well, if we
it would be
misled you,
on
we
the-
apologize. We don't try to do people that way, so.
Okay, but, you know, for sure, it will be on the next policy meeting.
Well, I'm not gonna be here, so I can't shake my head yes, but, someone who's likely
I'll
to
be
be here
happy
next
to
year.
bring it.
Thank you.
next
Would
time.
you?
I was gonna say, I think that's what you're looking
Yeah,
for, is you need a
yeah,
commitment
that's all
from
I
a
need.
particular board
That's
member
all-
to do it.
I'll be happy to bring it forth.
Exactly, you don't, you know, I would just like to, right.
Right, well, we apologize for the confusion. If we said that, somehow we dropped the ball, I guess, but it'll be on the next one.
Okay,
And it'll
thank
be in
you.
time for next summer.
It'll be next summer?
No, it'll be in time for any changes that might happen
Thank
to
you.
be put into place by
Thank you.
next.
Thank you, Ms. Sawyer.
Okay, any other business? All right, we're adjourned.